Friends, I think at the outset, I must compliment Healthium Medtech to arrange such type of a talk, which is possibly the need of the hour. Yes, medical negligence and a surgeon. But before I really move on to talking on the topic, the lawyer in me compliments you very big for being the front runner for managing COVID cases. And doctor in me is taking full pride that yes, we are fulfilling our duties. What I'm going to talk is on medical negligence and a surgeon, and we'll give you a broad overview. What are the laws? What are the regulations? What are the case laws that really play a role in, in managing medical negligence cases? But before that, I would like to disclaim that whatever I'm going to talk is purely with the objective of sharing my knowledge with you and should not be taken as an advice or an opinion in any matter. Today, if you see what is happening, what we are seeing today is a paradigm shift in medical profession. I became lawyer 15 years ago, and the way practice was being conducted in those times 15, 20 years ago and how it is being done today, there's a huge paradigm shift. A lot of things are changing. There are lots of challenges, lots of opportunities, whether you are individual practitioner or a group practice or in a corporate hospital. But as it is said that opportunities and challenges in any profession for that matter is like a seesaw. That sometimes you have opportunities up, sometimes you have challenges up. But end of the day, as a medical professional, we need to balance both the things. And why it is becoming more challenging is things are changing. What we are seeing is changing models of medical practice or medical professions. We are seeing significant changes in the deliverables. Patients are changing. What the patient we used to have few years ago, and the patient is full informed, well informed, or ill informed. And at the same time, what we are seeing today is the technology is playing significant role. But the most important thing that is happening today, which I think we are going to touch upon today, is law itself is changing, which was covering doctors, healthcare profession, hospitals. And that's what we are going to talk today. Now, when we talk of law, what exactly the law is, and then when a medical professional or a surgeon is going to perform his or her duty, uh, uh, is going to face some kind of good and bad. And fortunately, in medical profession, it is more good and very less bad. But again, things are changing. India was not that litigious when it came to healthcare profession, but of late we are seeing a lot of litigations happening in healthcare. So actually, how exactly the law plays role when it comes to medical negligence? We will discuss medical negligence, what it is, and what are the possibilities of liabilities. We will discuss in some time. But before that, let me just tell you what exactly is the legal angle. Some people call it legal tangle also. First is there is a problem with the professional misconduct. The duty, the service which doctor performed in the capacity of being a doctor was in some form a misconduct which he or she should not have performed. Friends, I think before I move on to, please feel free that whenever I speak he or she means both he and she. Second is, are there any ethical issues involved? It is always believed that ethics is heart and law is head. But many times when it comes to healthcare services, which is a noble profession, ethics play significant role, and many times heart rules over head or head rules over heart. End of the day, we have to balance both the things. Another problem which possibly we doctors per se are not very careful is on non-compliance with regulations. There are so many regulations which are required, which a doctor, a surgeon, or a physician, or any medical professional for that matter, in any area, so whether it is diagnostic or therapeutic, corporate or non-corporate, individual nursing home or a simple clinic, are supposed to follow. Many times, the negligent act may lead to civil or criminal liability. That also we will discuss in some time. Now, what is medical negligence? Before we really discuss on what exactly the negligence is, we need to understand what negligence is. Negligence per se is defined as an omission to do something which a reasonable man would have done, or a simple form is that doing something which a prudent and reasonable man would not do. So friends, when we are performing a services which otherwise a prudent and reasonable man would not have done, may tantamount to be a negligence. It can be anywhere, but when you're talking about medical negligence, so same definition which I explained above is when we perform during rendering medical services would tantamount to medical negligence. Now, when there is a medical negligence, I just mentioned what are the legal angles. What could be the outcome or what could be the consequence? It could be, as I mentioned, civil, criminal to a professional misconduct, etc. But the consequences that can happen because of medical negligence could be a removal from the register from Medical Council of India, or it could be providing compensation to the patient as decided by the court, or some kind of a settlement. There could be some civil damages, there could be some intangible damages, which is, I think, very important for a medical professional, especially surgeons who do either constructive or surgeries to help patient coming out from the disease he or she is suffering. And the goodwill which we have attained over a period of time by rendering such amazing services is always at question when there is some kind of medical negligence litigation happening in our career. And lastly, there is a possibility, I repeat, of criminal consequences, which could be either imprisonment to jail or a fine, or it could be both. I don't want to frighten you anywhere, but there is a possibility of liability in any profession. But because the doctors, especially surgeons, who are dealing directly with various organs of the body, are liable to potential liabilities. I will discuss about what exactly the surgical errors that can really occur leading to negligence and some kind of a problem little later on. But why medical profession per se is exposed to potential liability? And to some extent, I would say that medical profession itself is responsible, and a lot of various factors play a role. First of all, patient has become very aware. They are exposed to a lot of information. There is information pollution. They know right information, they know wrong information. At the same time, a lot of technologies are being used, so there is a possibility of technology mashup which can lead to some kind of a problem. But the most important thing I think I am worried is ki farak penda attitude. There is a attitude in management called ki farak penda, nothing will happen to me, aham brahmasmi type of situation, which unfortunately many of us have, that we are doing great service, so nobody can touch us. I think these are few pointers which really play a role in developing and creating potential liabilities. And that is why I think I firmly believe, and I am reminded of a quote by one former US Attorney General, and he very rightly said that if you think compliance is expensive, try non-compliance. Because many a times we as a doctor are always, I won't say afraid or worried of, but somehow we don't pay attention to a lot of regulatory compliances. But the time has come that we need to comply with regulations, which you have to, because it is very rightly said, things which cannot be cured have to be endured. And regulatory compliance is something like that you have to follow. And then if you don't follow, there are possibilities. So now I will touch upon first what is the regulatory scenario where compliance is required. I will also touch upon what are the acts that can lead to medical negligence. What are various case laws which are there? There are endless case laws, but I'll pick up few relevant and important. And most important, what surgical errors can happen which may lead to some kind of concerns and issues which may lead to medical negligence and related litigatory concerns, and what exactly we should do, we can do to avoid such things. A lot of things cannot be avoided, and I firmly believe and more convinced in last 16 years as of my career as a lawyer in pharma healthcare is that certain things happen only once in life and they are good enough to teach us a lesson. So let's avoid that. So first of all, I will just quickly touch upon what is the regulatory scenario. It is very important to understand that when a doctor is performing a duty, either as a singular clinic or nursing home, which has some indoor facilities with some diagnostic facilities, including X-rays or laboratories, ICUs, some have pharmacy stores, some, and so these are various things which have some kind of a requirement. So I think there are requirements from premise point of view. India does have a law called Clinical Establishment Act. However, it's a state-specific law, and not every state has signed to that. However, in a state where there is no Clinical Establishment Act enacted, there are local requirements from either municipal corporation or a municipality to perform or render services which you need to be aware of. There are certain requirements which you must have approvals you require for certain diagnostic facilities, especially like X-ray machines and other things. For various services required, you need some type of accreditation or maybe approvals and licenses. Pharmacy is a very big point. It depends what exactly the pharmacy is, who owns the pharmacy, and not being in compliance with certain basic requirements under law, which is Drugs and Cosmetic Act and rules, as well as Pharmacy Council regulations, it can lead to significant problem, as pharmacy is one of the important revenue stream for any hospital. Another important thing which is really important, of course, on the minor setup it has been taken care of, is on the biomedical waste disposal, which appears to be very simple law, but it is one of the most onerous law, and which we have seen in my practice, especially on a big setup. Non-compliance may lead to closure of the hospital for some time, which may become a big and huge concern for all of you. However, in small setup, we have a contractual arrangement with people who collect and dispose of the biomedical waste and take down. And recently, when we are using technology, and especially when digital health is very much there, data privacy plays significant role. India does have data privacy regulations, though at present there are just simple rules under Information Technology Act, where for your point of view, I think what is important for you all to know is that you must have a consent from the patient specifically for sharing their data in an electronic form to third party. This should be over and above, because many a times you sending medical records of that patient to another doctor over email or WhatsApp tantamounts to sharing of data with third party in electronic form. India has proposed general data privacy bill, which is likely to see light very soon. There was also a proposal of DISHA, which is Digital Information Security in Healthcare Act. However, both these bills are in draft form. General data privacy rule is going to come early, and DISHA may not happen very soon. But what I'm trying to say is that data privacy compliance is a very important factor for you to understand and be aware of. Now, after this, let us quickly know what are the laws that are applicable. Friends, I'm not here to frighten you, please. I'm here to help you. But I must tell you that what are the laws that governs whether you are a surgeon or a physician or any kind of healthcare service provider. The laws are many. Which are so many laws. It's as I mentioned, Clinical Establishment Act, which is a state level regulation. You have Narcotic Drugs and Psychotropic Substances Act. You have prenatal PCPNDT, which is prenatal sex determination. You have Essential Commodities Act, environmental laws, so many laws, right from pharmacy regulations to food and safety. I don't want to elaborate, but there are so many laws which I think you must comply. But I will touch upon briefly on 5 important laws. One is Narcotic Drugs and Psychotropic Substances Act. Every surgeons would have some kind of narcotic substance or a psychotropic substances like pethidine, morphine, and in fact recently tramadol has been added to this list. And storing and stocking these medicines does require some kind of licenses and compliance with the law, and non-compliance has very onerous implications which could lead to some kind of a criminal consequences, which may lead to some serious consequences. Disha and Data Privacy Bill I just mentioned. Consumer Protection Act, I'm going to touch upon this separately. And Drugs and Magic Remedies Act, actually full form is Drugs and Magic Remedies Objectionable Advertisement Act, which has certain requirements for pharmacy as well as doctors to perform certain duties which avoids claiming cure, treating, diagnosing a particular disease which is mentioned in the schedule. And Prevention of Corruption Act, if any of the surgeons who are involved in government services in some form as a full-time or a part-time or a consultant, you tantamount to become a public servant under the definition, under the provisions of Prevention of Corruption Act, which just got amended, which added that the person who gives bribery as well as accepts bribery, both are considered to be offenders and may be subjected to consequences under that. Drugs and Magic Remedies Act also is going towards amendment, and there are certain proposals which have been put which are under discussion. I will quickly touch upon Consumer Protection Act. Recently we had some amendments and there was some kind of ease in the minds of doctors that hey, healthcare services are removed from the Consumer Protection Act. But if you read the fine prints of the amendment of Consumer Protection Act, doctors still can be held liable for deficiency of services under Consumer Protection Act. Now, where exactly Consumer Protection Act would touch upon surgeons or any medical professional for that matter? Endorsements. Many a times you are endorsing certain products as well as your personal endorsement, giving advertisements or photographs or somewhere where you claim certain things can lead to certain problems. Healthcare as a service I mentioned, though it is not there, but the liabilities on part of doctors have not been removed. And another important point which can play a role, especially for surgeons, is product liability. Whether you are a general surgeon or orthopedic surgeon or ENT surgeon, any product which you are using in a reconstructive surgery, it is difficult to prove the quality of product, but it is easy to prove the methodology which was adopted by a surgeon to put there. So this type of product liability claims we have seen in our experience where doctors are immediately held liable, and the onus is on doctor to prove that it was not my fault, it was not a faulty technique adopted by me which led to the problem to the patient. Possibly it was because of the product or some other situations. So I think this is broadly the legal provisions which are there which affect, impact and influence healthcare profession, especially medical field surgeons specifically who are doing a lot of constructive surgeries also. So purely from Product Liability and Consumer Protection Act, we need to be aware of these situations. So we discussed about what are various laws and regulations which are important for medical profession, especially surgeons, with which the compliance is required. Now let's talk about actual laws, rights and liabilities which hospitals and doctors, especially surgeons, can have. Now what are the laws that really play a role when a liability happens or there is an incidence of medical negligence? Of course, first is Indian Penal Code. Second is Consumer Protection Act I just mentioned. The most important thing is Medical Council of India Code of Conduct, Code of Ethics, and the Law of Torts. Now, Indian Penal Code deals with criminal negligence or liabilities criminal where there is a provision of imprisonment up to life, as well as death sometimes. Consumer Protection Act, as I mentioned, though healthcare service is removed, deals with inefficiency or deficiency of service. Medical Council of India, which is of course now National Medical Commission. However, the code of ethics which was proposed by Medical Council of India is still being practiced. It talks about and deals with professional misconduct and non-compliance with the guideline. And law of torts is mainly talks about civil liabilities. Let us quickly talk about how exactly the doctors, the surgeons, and law are impacting each other. As I mentioned, patient is a consumer and has certain rights. Unfortunately, doctor is no longer God in the minds of people, but doctor too does have a lot of rights. Both doctors and patient do have defense mechanisms. It is not that only patients have defense mechanism. Doctors also have defense mechanism, which could be in the form of obtaining informed consent, obtaining insurance or indemnity in insurance, or there are various case laws or the orders by various courts, right from Sessions Courts to High Court to Supreme Court. There are so many orders and judgments which are considered precedents in legal language, play significant role. But the biggest challenge today we are facing is, I call them Google Bhai. No offenses to Google, but providing excellent information which is required. But many a times the way information is being accepted by the patients or people at large and how they are interpreted, because medical science is a complex science, and you being a surgeon would agree, and I don't have to say this to the audience which is comprising of surgeons, but people need to know that yes, 1 plus 1 is 2, but in surgical science 1 plus 1 could be sometimes 11, because what is mentioned as A, B, C, D may not be applicable for a particular disease, and the same disease may have some other modalities of therapy or a remedy which only surgeons would understand from clinical experience. So this is broadly the things which we need to understand. Now let us understand what are the rights. Let us talk about rights of the hospitals. There are plenty of rights. I am not going to discuss many rights. Hospital has a right to refuse patients. Depends on circumstances, but that doesn't mean that hospital has to admit the patient, depending upon the facilities available, etc. However, all these rights, etc., do not hold true when there is an emergency situation and the patient who has been brought to the hospital requires emergency intervention for survival. Hospital also has a right to demand autopsy in case of death, which hospital feels that autopsy would help them to identify the cause of death. Hospital also has a right to transfer the patient to better facilities, other facilities, depending upon the situation and circumstances. However, there are certain requirements while transferring the patient. There is a right of DAMA and DOR, which is discharge against medical advice and discharge on request. And there are many more rights. At the same time, doctors too also have the right. Whatever rights I mentioned for hospital, doctor is practicing as a single doctor or a personal nursing home. Those rights hold true for them also. But apart from that, doctors are unfortunately at the receiving end. And of late, it has increased significantly. And that is where I think the seesaw which I mentioned about challenges and opportunity, same way there is a seesaw of rights versus responsibilities for a doctor. And the doctor needs to balance both the things. However, the most important thing, doctor has a right to choose his or her patient other than emergency situations. But apart from that, I think the patient has many rights, and I'm going to talk more about rights patients have, because we are discussing medical negligence, where patient is the most important element into the entire litigatory process. Patient has a right to choose doctor, choose hospital, and if there is a question of referral, which I just mentioned earlier, then patient has a right to ask for options, that which hospital should I prefer. They have a right to demand efficient services. They have a right to provide detailed and explained about what surgical procedure or surgery is going to be performed. They have a right to ask your qualifications. The patient has a right to ask qualification, and if doctor is found not complying with this right, can become a concern for the doctor. Patient has a right to refuse treatment. Patient has a right to maintain his confidentiality. That is where again data privacy, which I just mentioned. Patient has a right for second opinion. Even if doctor has admitted a patient and scheduled for a surgery, say there is a patient for X disease has been scheduled for surgery next day, and in the afternoon that patient comes to you and says, hey, I want a second opinion of by another doctor, and it's a right, and it would be difficult, or it would be slightly complicated situation for a doctor if doctor refuses for such second opinion. In fact, obtaining second opinion is a significant defense mechanism for doctor in case liability and litigation, which we will discuss later on. And the most important thing is patient has a right to have or get case papers when he's requesting for that. Sorry. Now, so these are the rights of hospital, doctors, and patients. You must be wondering, I have nothing, but this is a fact. I'm talking about law. Now let's talk about what are the liabilities that can happen. As I mentioned, there could be liabilities on hospitals and patients. There could be liability because of the non-compliance, which could be unethical act or a professional misconduct as per Medical Council of India Code of Ethics. There could be liabilities because of the medical negligence, which is an obvious medical negligence. Again, we are discussing in some time what exactly the medical negligence and what can be prosecuted, and deficiency of services. So these are the liabilities that can happen. And when I discuss, these are the incidences that can happen. Let's talk about what errors that may happen. And this list can be endless. I thought of preparing the list, and it was becoming a laundry list of maybe what a patient would perceive as a negligent act or an error. I'm talking just about the error. I'm not talking about the negligence. But negligent act starts from the error. And if error is led to that negligent act, which is grievous, may lead to liability and litigation in future. And you can complete this list what I'm just mentioning. But I think the errors that can occur because of surgical intervention or during the performance surgery, which I prepared from few case laws and asking few people and our experience and being an ENT surgeon for 15 years. First of all, I think injury to key adjacent organs. It can be, nothing happens advertently in healthcare by a surgeon. I must tell you that. And I think law also is aware of that. Judiciary also is aware of that. Exceptional situations, however, do happen. Second is operating on the wrong side. I know it's a somebody may laugh, but it's a fact. There are incidences that patient is operated on the left side rather than instead of right side, leaving something inside the patient, which has been found post-operative due to some kind of morbidity. There could be cotton swabs, there could be mops, there could be a small equipment or instrument while performing tonsillectomy. A gauze may remain inside. I have removed few. Wrong surgery, very interesting thing. There was one case where possibly the surgery was wrong, I don't want to debate on this, but such situations may happen that, hey, this surgery was planned, but this surgery happened. This may be perceived by the patient or patient's relative, but we need to have some kind of mechanism that when we change this type of surgery, then what was explained to patient may become a problem. So whenever you are explaining or detailing the patient about what type of surgery is going to be performed, always talk of intra-op decisions you may have to take while performing the surgery. It's very important point as a defense against any liability and litigation. Many a times patients have doubted poor surgical skills. Again, it is difficult to prove, but there are incidences where patients have doubted that surgeon was not trained enough or did not have the proper skills. Maybe they doubt your qualifications, but these are the things. List is endless. Another important thing which we need to be very careful and very, very often it is happening is errors while giving medications. One, post-operative and pre-operative errors by you or your staff is one thing. But here I just want to touch upon a very important part which surgeons face, is that medications given by anesthetists. Should surgeon be held liable for some error done by anesthetist by performing surgery? It depends on how exactly these services are being rendered, and is there any kind of a documentation which a surgeon has entered into with anesthetist, especially from liability and indemnification point of view, which is not practical. I totally understand. I can see some doctors frowning listening to this, but this is a fact that patient knows doctor and patient is going to sue the doctor. It would be on the doctor, it is the onus on doctor to prove that whatever happened was because of the anesthesia medication problem, and that is where I think the soft or hard contractual arrangement a surgeon has with the anesthetist plays role. Same thing may change the flavor if you are working in a hospital as a surgeon, full-time or hospital. That is where I think the relationship between you and hospital is going to play a significant role, which we are going to discuss when we are going to discuss checklist. Now, I have been talking a lot about negligence. I also mentioned what is the negligence, that somebody else would not have done this, but you did. That's why it was negligent. But now, I think medical negligence, the most important point is that when a medical negligence comes into picture, especially from offense point of view, there is a legal term called mens rea. There must exist the mens rea, which is motive to do harm or intention to do harm must exist. If that mens rea is not exist, or judiciary has been convinced that there was no mens rea, then that medical negligent act may not be an offense. Again, for a negligent act to be criminal negligence, the degree of negligence plays significant role. To prove to be a negligent act as a criminal negligence, purely from medical point of view, the act has to be very grave, grievous hurt needs to be there, or in a common language, it should be of a very, very high degree, like death or loss of extremities or loss of performance of vital function. Like, for example, somebody because of eye surgery becomes blind, becomes a grievous injury, could lead to criminal liability or criminal negligence. Now, as I mentioned, when you get liable, so grievous hurt is one, but another important point I would just read from the law, a professional may be held liable for negligence on one of the two findings. One, either he or she was not possessed of requisite skill which he or she professed to have possessed, or he or she did not exercise with reasonable competence in the given case the skill which she or he did possess. So if you are not given your 100%, has been proved may lead to some kind of a liability because of negligence. The standards which are applied while judging is an ordinary competent person exercising ordinary skill in the profession would have done it. So this is very important point we need to understand. And let me touch upon possible prosecution under criminal law. That is when there is a grievous hurt, criminal negligence, which has led to very high injury. No medical professional, or let me put it that way, there would not be any criminal prosecution. No medical professional in his or her ordinary senses and prudence would have done or failed to do so. That under ordinary circumstances, this would have happened. The hazard taken by the accused doctor should be of such a nature that the injury which resulted was most likely imminent. That is where mens rea comes into picture, that whatever injury, grievous hurt that happened because of the reasonable act on part of the surgeon was imminent, that hey, because I am doing this, this is going to happen, is going to lead to some kind of criminal liability, which usually doesn't happen. So I think this is broadly, I talked upon what are the negligent act, what is medical negligence, when it can go to criminal, when it could go to civil, and of course, other than that, anti-bribery provisions, Consumer Act provisions, Medical Council of India. So this is broadly, I think the one must understand how liabilities can happen and how it can really lead. And again, I tell you that establishing a mens rea in a medical negligent case, especially in surgical situations, are not that common. And as I mentioned, that there are case laws and orders by various judiciaries which provide some kind of a precedence and defense mechanism to discuss. So I will touch upon now some important case laws which give us some understanding what should be done, what should not be done, or leads us to kind of a best practices which will kind of a ring fence a surgeon from a liability coming out of some negligent act. Let me touch upon few important and relevant case laws. When a lawyer says case laws are the orders or judgments given by various courts, and there are some very interesting observations by either the High Court or the Supreme Court in various matters of medical negligence or where a doctor or hospital was involved. First is the famous VP Shanta case. This case established that a patient is a consumer, and that is how the patient became a consumer. An entire healthcare service, medical service, or a surgical service which has been rendered came into the ambit of Consumer Protection Act. However, Consumer Protection Act, as I mentioned earlier, got amended recently, and the healthcare service is removed from that. But that has not absolved doctors or surgeons from potential liability that may arise out of deficiency of service. Second interesting case was a Nizam's Institute of Medical Sciences case. Very interesting case, very interesting case. And what it established, that once the initial burden has been discharged by the complainant, which is possibly a patient or patient's relative, it is up to the hospital or doctor to prove and to satisfy the court that there was no lack of care or diligence leading to any negligent act. However, this was one of the case laws where significant amount of compensation was awarded to the patient. It also established certain facts that informed consent doesn't always give you 100% immunity. And it is true. Obtaining informed consent doesn't mean that a doctor can do anything and everything inadvertently also. And I'm sure you are aware of this case where there was incision biopsy versus excision biopsy and mediastinal mass was removed. But the finding of the court, I'm just verbatim reading, the court held that there was negligence as the case should have been referred to the neurosurgeon as the tumor had extended into the intervertebral foramina. I'm sure I did not explain this to the surgeons who are listening to me. But this is where the concept of second opinion or referring a patient to a better facility or the right facility or the skilled personnel comes into picture purely from liability point of view. That court in this case observed that because it was going to intervertebral foramina, neurosurgeon should have been involved because patient ultimately suffered from paraplegia, which otherwise would have happened, but court goes by facts. And that is what the finding is. That the message here is that please involve a skilled doctor in a situation when you personally feel that you are not skilled to perform that surgery. I know it may sound slightly difficult, but in like this situation, if general surgeon was doing and possibility of neurosurgical intervention was required, or you are doing some head and neck surgery for a cancer, and you feel that, hey, oncosurgeon needs to be involved, then involve them. That is very important from liability point of view, providing a defense. And there also is another very important case law which I am going to discuss later on. Another very interesting case law was Martin D'Souza versus Mohammed Ishfaq. Very interesting case where it was discussed that medicine should not be prescribed over telephone, or no significant advice should be given on telephone unless or except in cases of emergency. However, this is a Supreme Court judgment. They have given guidelines. They have not mandated everybody to do so. What we do is being done, but if it is not in compliance with law and a liability arises and there is a litigation or a suit filed by the patient or patient's relative, then the court is going to refer to Jacob Matthews versus Martin D'Souza for sure. And that is where, hey, this has been advised, but this doctor ideally should have followed it. If doctor had followed, these consequences would not have happened. So this type of situation does happen. And it says that doctor was not negligent. It was a very interesting thing that doctor was not held negligent, but it was regarding not doing certain tests, etc. And patient was in a renal failure, and ultimately patient went into chronic renal disease and went into renal failure. But that is where I think issue was administration of amikacin in this case, and ultimately court held that a doctor took all precautions and why it was happened. It's a very interesting case law. You should, in your free time, should go through. But it talks about advising patients on telephone especially, which we'll discuss in the present scenario, has slightly changed. Jacob Matthews versus State of Punjab has laid down very interesting guidelines, and it has talked about guidelines that to be kept in mind before initiating the medical negligence proceedings. Very, very important. And I think this is considered to be a game-changing order, when it came to medical negligence and court proceedings. What it says that private complaint may not be entertained unless the complainant has produced prima facie evidence. This is so important. And that is where I think the medical fraternity, we the surgeons sometimes falter. That it is very important for a complainant, which is patient or patient's relative, must put significant, solid, strong, powerful evidence to support his complaint. And that is where I think the biggest defense mechanism lies for us. It also talks about whether possible opinion was obtained or not. The guideline further says that investigating officer should, before proceeding against the doctor who is accused of rash or negligent act or omission, obtain an independent and competent medical opinion. The Jacob Matthews case guidelines says 1. Requirement of a prima facie evidence on part of complainant. The investigating officer must obtain an independent opinion on the matter by a competent, skillful professional. Third point, the guideline says a doctor accused of rashness or negligence may not be arrested in a routine manner simply because a charge has been leveled against him. Very important. That nobody can just arrest doctor just like that. However, the word used is may. That doesn't mean doctor cannot be arrested. That is where again how you have prepared yourself from documentation point of view, evidence point of view is going to play significant role. However, just because there is a case against you that has been filed or there is a complaint against you that has been filed, no one should arrest you. That is what the guideline says. And the last thing it says, doctor is not liable. I'm again talking about Jacob Matthews versus State of Punjab case. It said that doctor is not liable as Bolam test was not fulfilled. Death due to non-availability of oxygen cylinder, which was the fault of the hospital. So I don't want to go much into the hospital versus doctor, but what is important is Bolam test. And I'm going to talk about this Bolam test, which again is the most important and very relevant and possibly the best defense a doctor has, to which doctor has to agree, unfortunately. I will just read out the ratio and then finding. Where the defendant, it is a 1957 case law in UK. It was Bolam versus Freedom Hospital Management Committee. It says where the defendant has represented him or herself as having more than average skills and abilities, that is, as a professional, quote unquote, as all doctors do. This test expects standards which must be in accordance with a responsible body of opinions, even if others offer in opinion. In other words, it says, if a doctor reaches the standard of a responsible body of medical opinion, he is not negligent. I repeat again. Where the defendant has represented him or herself as having more than average skills and abilities, that is, as a professional, as all doctors do, this test expects standards which must be in accordance with a responsible body of opinion, even if others differ in opinion. In other words, the Bolam test states that if doctor reaches the standard of a responsible body of medical opinion, he is not negligent. Now I'll read out finding. Doctor was not negligent as was divided opinion amongst professionals as to whether relaxant drugs should be given. If they are given, there is a very small risk of death. If they are not given, there is a small risk of fractures. So what this Bolam test says is that when you feel that second opinion should be obtained, please obtain. Let me simplify Bolam's test. When you are operating a case, let me start to pre-operative situation, that you have come across a patient who requires surgical intervention, and you have decided, hey, this is the surgical intervention that is going to benefit the patient. But if you anticipate some kind of complexities, longer time for surgery, though not necessarily a major criterion, but possible complications or rare disease or not frequently performed surgeries or just like that, please involve another surgeon who is equally or higher qualified. Call that doctor and let that surgeon pen down his findings on the case paper, which supports the decision which you have taken. If this has been taken, this gives you significant defense in case of liability arising in this situation. Intraoperatively, if you find that, hey, the mass or the anatomy is slightly distorted or mass is slightly bigger, it has gone beyond your anticipation or may lead to some kind of sequelae in the form of morbidity to the patient post-operatively, please call another surgeon and let him opine, put his findings on a case paper, or may help you, or you both can perform surgery together, is going to give you significant difference. So I think Bolam test is a very important test, and that is where I think the challenge possibly is there. Why call another doctor? Things are changing. So my personal request, especially you are performing this as a solo practitioner in your nursing home, in your own operation theater, please involve other colleague who is equally qualified or higher qualified, not necessarily every time, but when you feel that it's slightly complex or complicated or could lead to some kind of morbidity to the patient post-operatively, that is going to be a huge defense mechanism for you. So these are broadly case laws which I think there are many. There are recent case laws in Maharashtra of Pavaskar couple who are gynecologists, and they advised something to nurse on phone and led to some problem, and anticipatory bail was not granted by Bombay High Court, which went to Supreme Court and bail was granted. There are many case laws which guide you. It is important for you to sometimes in your free time, there is no need to go to all the case laws, but keep your eyes and ears open on such judgments which definitely give a very good defense in case of liabilities. Now let me touch upon prevailing situations, which is this pandemic era, the COVID-19 situations. You have not stopped your practice. Could be selective, maybe cold cases are not being done, or you are treating some emergency cases. But many doctors are deputed in rendering services to manage COVID patients. So two things I want to mention here. One is there is an act called Epidemic Disease Act of 1897. Still holds true. This act gets enacted on a special situations of epidemic. Most of the states in India have enacted Epidemic Disease Act. Very short acts, 4 or 5 sections. But the section 4 of this act, Epidemic Disease Act, is very important, very relevant for you all to know. The section 4s, I read out. It provides protection to persons acting under Act. No suit or other legal proceedings shall lie against any person for anything done or in good faith intended to be done under this Act. So, if you are treating any patient suffering from COVID-19 and further complications attributed to coronavirus in this epidemic, you will not be held liable for anything. Second important thing that has come up very recently, it happened I think in the week of 23rd March, I think 27th March it came, that the Board of Governors of National Medical Commission, Medical Council of India, along with Niti Aayog, came out with telemedicine guidelines. And this, I'm not going into details of these telemedicine guidelines, but this provision, this notification has permitted online consultations and remote consultations, as it is not possible for patients to access doctors in the situation of lockdowns. This is what I think you need to be aware of. Now, after this, I talked a lot about liabilities, negligent act, litigations, etc. Now, let me go on the defense side. Now, I'll talk about potential litigation. When there is a litigation which is impending, or there is a situation when you receive a notice from the patient or patient's relative, remember one thing: you have to face the lawsuit. You don't have any immunity unless, as I mentioned, it was as a part of Section 4 of Epidemic Disease Act. But I'm talking general. You have to face lawsuit, and we do not have immunity. However, every surgeon has a lot of defense mechanisms, defense situations, and best practices that is going to help you coming out of this lawsuit. So, how to manage it? First is keep calm. Keep calm. It is just a notice of a lawsuit, doesn't make you guilty, doesn't prove that you were negligent. Keep calm. Please read the notice yourself carefully in detail. If required, read it more than once, twice, thrice. Just don't pick up the phone and call your lawyer friend. Okay, I received the notice, please manage. No. Please read that notice thoroughly in detail. Try to understand yourself first. Why this notice has come? What is the objective? What is the purpose? And what are the points put in that notice that is making you guilty of performing some negligent act? Don't forget, even though you are not a lawyer, please read the notice has come under which provision of which law. Whether it is Consumer Protection Act, whether it is a Indian Penal Code, whether it is anti-bribery law, please read that. I don't want you to be very law savvy, but always because that is going to help you understand the situation and develop the defense in the suit. After this, always check on the documents, case papers, and whatever related and relevant materials you have regarding that particular case, right from OPD findings to discharge to follow up. You must keep them together, keep them aside, go through them. But the most important thing, do not tamper with those documents or case papers. it is very easy for court to find out that you have tampered it. There are forensic experts in India who are called to provide services to find out whether a particular document is tampered or there is forgery or there is something which has been done on part of the surgeon or a doctor to create a false defense. It is the color of the ink, it is the whether it was written with fountain pen first and then ballpoint, it was written by ballpoint and later on you have written with pencil, you have changed color suddenly. Even the forensic experts even see the intensity of the stroke while writing. So if you are writing something at the time of surgery and if you have written something when this notice came, it is not difficult for that forensic expert to find out just looking at the stroke, looking at the intensity of force with which you have written, including the angles of your letters in the words. So my request is don't tamper, please. It will put you in more trouble than what otherwise you would have been. Then you need to talk to your lawyer. Don't say lawyers are not required. You need to talk to lawyer, show him the notice. After he reads the notice, before lawyer asks you question, you explain everything, the scenario. How patient came to you for the first time, till advising on surgery, pre-operative, intraoperative, post-operative, discharge and follow-up. Most important thing. Then answer all the questions which lawyer asks you perfectly. Then you need to discuss the response with the lawyer to that notice. Always ask your lawyer to run through the response to you before it is sent to the complainant. Very important. You must read the response which is drafted by the lawyer. The lawyer is a lawyer is not a surgeon. And then another important thing in case of litigation, don't lie. Rather, I put, never lie on any facts, especially when you are appearing in a court in this particular situation. I tell you, the law is not that blunt. If you have proper things in place, documentation, which proves that there was no mens rea or there was no intention to do harm, the law will be with you. Now, let us discuss a kind of a watch list, what you should be aware or what you should be careful of. Now, let us talk about what are the pressure points in the entire process of dealing with patients, talking with patients, operating the patient, discharging the patient, and talking to patients in the follow-up post-op. Very interesting situations. And honestly, I never realized that all these things are important when I was an ENT surgeon for 14 years in Gujarat. But I realized it while going through a lot of case laws, precedences, certain matters, and many corporate matters where the investors ask us to perform due diligence on the hospital or the doctor, and we found some very interesting litigatory process which should not have happened, led to delaying of the deal or failure of deal just because of simple non-compliance. Talking to patients is very, very important. I may sound a little bit philosophical, but you have to go beyond trust. and emphasize on the facts. Please, while you're talking to patient, have your head rule over your heart. Very important, because facts are important. Don't try to hide potential complications for the fear of patient not agreeing to surgery. It will come a very bad way in future if something goes wrong to that patient. It can go wrong if that patient goes to another doctor and something goes wrong, and then it may come up that, hey, I went to that doctor, but he or she advised me like this, which may possibly wrong, may lead a problem for you. Second point is informed consent. Please do not ignore this small piece. Ideally, may not be practical, is to have detailed informed consent for individual cases. We have printed written form which we just explain and get signs of patient and patient's relative. Sometimes we add with our handwriting or pen, additional points. So whenever you add such things, do countersign on that particular scribbling which you have done with the pen on a printed piece of paper. But the message is you have to explain in detail the procedure, what are the options, what are the possible complications or potential complications, the possibility of sharing data with others in view of data privacy laws. That consent can be a part of the consent that patient gives you for surgical procedures or surgical intervention. And always check on witness, who that witness is. Always check for relationship of that witness to the patient. And whatever the relationship is, you must mention in the consent form against relative, brother, father, mother, sister, mother-in-law, father-in-law, whatever it is, or even friend sometimes. You must write that. Another important point, if you are dispensing medicines yourself, one point is pharmacy. You have your own pharmacy. See that all the compliances are done under Drugs and Cosmetic Acts and rules. You may be the owner. So just see the relationship of that pharmacy with you and your hospital management or whatever it is. Pathology reports. If you have your own pathology lab, you have autoanalyzer, you are doing some basic hematological and some test, do not sign those reports being a surgeon. That could be indicative, or have pathologists sign that report by sending them to weight them. If you have your own radiology setup, many surgeons these days, even a private nursing home setup, have X-ray machines and sonography machines. Please don't sign on the report. It may be an indicative additional information to you to manage the patient, but if you want to establish your finding, it must be vetted and reviewed by a radiologist, qualified radiologist, who signs on that. Very important point. Very, very important point. Nursing care. Please have proper relationship, contractual relationship with nursing care. They might be your employees, or you must have hired third-party service provider. There has to be a proper contractual obligations defined. Disposal of waste, especially biological waste, you have to comply. You would have entered into a setup which is providing services of collecting your waste. Please don't have a very casual relationship with them. Enter into a proper contract, especially from liability point of view. There has to be a limitation of liability as well as indemnification provision in their contract, that service provider indemnifies you for any claim arising out of non-compliance because of their negligent act. He throws on the road because non-compliance of biomedical waste leads to closure of hospitals sometimes. You have obtained approval under biomedical waste from the environment authorities when you had a small setup, say 20 beds, because it is important to mention number of beds in the consent. You expanded and you added another 20 beds and you are 40 bedded hospital. You have to intimate the authorities on additional beds and take fresh consent from them to operate, mentioning additional 20 beds. So your earlier consent which mentioned 20 beds, unless new consent is obtained which mentions 40 beds, you are not complying with biomedical waste provisions. Very important thing which we have observed. Professional indemnity insurance, obtain it. My personal take is try to obtain highest possible amount which is available. Participating in clinical trials, great. Some people call it topping on pizza for doctors. Please pay full attention to documentation. You will be called principal investigator under law, and you will be the most important stakeholder in the conduct of clinical trials, and you will be entering into clinical trial agreement either with the CRO or sponsor, which is a pharma company. Please see what are your roles, responsibilities, obligations, and what are the representations and warranties you are giving in this agreement, and what indemnification clause leads to and reads also. Please see this. And when you are conducting a clinical trial as a full-time employee of a hospital or a consultant to hospital where institution is a party to the clinical trial agreement, your contractual relationship with hospital is very important. It is very, very, very important, where having some infrastructure problem while conduct of clinical trials should not lead to liability for you, for which you are asked to compensate the patient. I don't want to go into the details of compensation where obligation is mainly on the sponsor, but if the contract proves that negligence was not on part of the sponsor, the compensation liability comes on either CRO or a doctor or the institution, as the case may be. Now, that leads to one very important point. Today, we are seeing multiple types of practices, business model. You have corporate hospitals, you have small hospitals, you have independent nursing homes. So one surgeon renders consultancy services at more than one locations. If you have your own setup at multiple locations, I'm fine. But if you are going to an established institution as a visiting doctor or a consultant, don't remain comfortable and happy with simple letter which says, we are happy to have you visit our hospital on Monday, Wednesday, Friday from 10 to 1 as a so-and-so surgical specialist and operate in our premises. No, you must enter into a proper consultancy agreement which defines your roles, responsibility, hospital's roles and responsibilities, and what happens in case of claims come because of some kind of adverse effect or some kind of morbidity or mortality happening to the patient whom you have operated in that hospital. Who will be held liable? That clauses must be properly read, reviewed and included in that agreement. If you are a full-time employee, your contractual obligations with hospitals are paramount because there is a concept of vicarious liability which is there in employer-employee relationship, and employer will always be held liable for the enactment on part of the employee plays role. If you are associated with government hospitals, please be careful on anti-bribery laws, which is Prevention of Corruption Act. Never act anywhere on your own. Always take permission from your senior in any designation or form in that particular department in government hospital is going to give you immunity against any kind of liabilities. So these are the pressure points and things which you need to be aware, careful. I am very sure that you all are following this. But the most important point is documentation. Please see that you document everything. If you follow this, I am sure it's going to be very helpful in managing a potential litigation in case of medical negligence for you all surgeons. I talked a lot about negligence, litigations, liabilities, what are the pressure points, what you should do to avoid litigation, or if there is a litigation or a suit filed, what are the best situation you can manage. So I think let me briefly discuss few important takeaways, especially in the present times. So let me first, two parts I will include. First is improve the hygiene of your services, which includes hospital or whatever you perform, the models. And second is following the typical principle of prevention is better than cure. Let me first talk about basic hygienes. And this is coming from my experience managing various transactions involving hospitals, whether it was a single specialty, multi-specialty, top-end hospital, to simple group practice somewhere in Gujarat. Very important things I think I must share with you. Of course, it is up to you whether you want to follow these or not. But it is said that let's start one day. First is, it's a very common practice. I think this is referring to more those surgeons who have your own practice, own nursing home, big nursing homes, or 2 or 3 friends or family of surgeons who could be one orthopedic surgeon, one general surgeon, neurosurgeon, any surgeon working together in a hospital. Parking corporate hospitals in this discussion for a while. First is consider formalizing the structure. By and large, there is no structure. You are doing your service, somebody else who is your wife or rather your spouse or son or a daughter-in-law or a son-in-law, all working together of the same discipline or different discipline. You just work. There is no sole proprietorship firm. You just render services, pay the salaries, do expenses from your accounts. It's a quasi sole proprietorship situation. You have family members working with you. They all work independently. Or sometimes there is a quasi partnership thing, but there is no partnership deed. So my suggestion is to formalize this structure by either forming a private limited company or a limited liability partnership companies, which then enters into a contract with individual doctors or to perform services. The important doctors can become a serving partners. The reason is that all the contracts which will happen would be in the name of that entity. So the liabilities would be confined to that particular entity and not to you individually. I'm giving you very broad outline, not going into the intricacies on details. We have to understand the situations, case on case basis to come out with the best possible structure, even if it is a limited liability partnership LLP. Another important point is LLP should play a significant role, as all the expenses would be done by LLP, and once all expenses are taken care of and the revenue comes in LLP would pass that profit to the partners of the LLP, and the share that is received by the partner from the profit of LLP by incurring expense as well as paying tax at a particular tax rate would be non-taxable in the hands of partner. But having a proper structure gives you few advantages. One, the liability would be limited to that particular entity as well as to that particular partner's performance. Second, it gives you a formal structure on documentation. And third, if you are looking at expanding and expecting some investments to expand your hospital, it would be very easy structure for the investors to invest money either in the form of equity or the share in LLP. If second point is, if you are adding or rendering various services, create separate heads for those services: nursing care, pharmacy, certain procedures, non-surgical care, and you can be creative with your own self and create different heads. As and when required, contract with third-party service providers on securities, on nursing, and just enter into a service contract which give you indemnification to you against any careless or negligent act on part of nurses. See that you have full regulatory compliance. That is very important. Don't ignore a single, even obtaining a spirit license is very crucial. But the most important thing which we have observed is on the renewal. Doctors sometimes fail to renew the approvals and licenses in the time, which may lead to some kind of a consequences. Try to create IP. IP is intellectual property. If you are all surgeons, if you have devised a technique, create a copyright over it. Just do a simple draft of the technique and just Control Alter C will give you copyright. Write the year and the month, it gives you copyright. And if you find it to be very important, very crucial, you can register that copyright, which is very simple. You just have to go online and do that. If you have devised an instrument, a very unique, you have modified existing, say, artery forceps or any cannula or anything which is helping you, please apply for design patent. However, there are certain requirements to be fulfilled, but it is important. If you have a strong goodwill of your hospital, the biggest thing which I think doctors miss is on registering trademarks of the name of your hospital. Not that you want to create a monopoly, but please, why I'm telling you all this, creating the IP is going to increase the value of your business. This may be helpful if you are looking at investments. And third is handle pharmacy well. I've discussed that. I'm not going much into the detail. And be conscious about creating goodwill. Goodwill is going to lead to huge branding, and that branding is going to give you huge positioning in your practice. So these are the basic hygiene I think I thought I must share, because having this hygiene also will give you significant defense against liability, as I mentioned, having proper structure, having third-party service providers, having IP, having managed pharmacy very well through proper contracts is going to help you defend yourself very well. And now what we should do just to avoid? I think I always believe, and I may sound slightly philosophical, maybe I became philosophical after I became lawyer for last 16 years, believe in a principle called anticipate, prepare and deliver. Always anticipate something may go wrong, something may become complex, remember Boehm's test, have somebody come and confirm your findings, your decision is going to help. Prepare, document everything, anticipate there is going to be some problem, if at all. Proper documentation, proper filing, proper opinions is going to help you, and deliver, be ready. So I think broadly you can categorize what you need into maybe 5 categories. Must be done. There are certain things which must be done. Documentation, informed consent, all those things are very important. Should be done. Be cautious, be careful. May be done, something which is okay. I should do this, I should not, may be done. Nice to do, there are certain things. Better I do this. Have better infrastructure, better technology, which is not mandatory. And there are certain things, okay, I don't do it. If there is anything which somebody else has done, which you do not have, is not going to impact on your performance as a surgeon while rendering surgical care to your patient, it's nice if you don't do. So don't be worried. But anything, I think, give a lot of importance on must be done and should be done. And that is why I said that the only non-negotiable in this entire negligence possibility leading to liability for you all surgeons who are doing great humanitarian work is only one thing, that document, document, document. Every single word written on a case paper of a patient has significant value, which will provide huge defense in case of liability against you, which could be a negligent act on mind of a patient, but it is not actually a negligent act on in the minds of court of law. So I just end my session with saying only one thing from Benjamin Franklin, that ounce of prevention is worth a pound of cure. Thank you very much. Wish you all the greatest times. Keep on making difference in the lives of people by curing with best possible surgical intervention. Thank you very much.